In this video, we will conclude our look at contract modifications by examining a final issue raised by modifications, namely the effect of no oral modification or NOM clauses. NOM clauses are very common in many types of written agreements. Indeed, when I was in practice, I always liked to include a NOM clause in any agreement that I was responsible for drafting or revising. Here is a typical example of such a clause. Press pause now to take a moment to read it for yourself. The idea behind NOM clauses is that parties can agree that the terms of a written contract cannot be modified or rescinded except by a signed writing. Stated differently, the written contract cannot be modified by a subsequent oral agreement between the parties or by an agreement manifested through the parties' subsequent conduct. In this way, a NOM clause gives a contract party the comfort of knowing that her conduct, course of performance, or something that she might say offhand after the contract was formed will not inadvertently result in the modification of the contract's written terms, a modification that could change or eliminate her express contractual rights. After all, a contract's NOM clause says that the only way that the contract may be modified is through a written agreement signed by the parties. Under the common law of contracts in some jurisdictions, however, NOM clauses are not valid or enforceable. That is, even if contract parties have included in their written agreement a NOM clause, some jurisdictions have ruled that any subsequent oral agreement to modify the terms of the written contract includes an implicit agreement to rescind or modify the NOM clause in that written contract. The net effect of this common law rule is that contract parties may always mutually agree to orally modify an existing written contract, even if it includes a NOM clause. Article 2 diverges from the common law rule in these jurisdictions. Specifically, subsection 2 of 209 explicitly authorizes and therefore confirms the enforceability of NOM clauses in contracts for the sale of goods. Subsection 2 reads, "A signed agreement which excludes modifications or rescission except by a signed writing cannot otherwise be modified or rescinded." So, subsection 2 confirms that NOM clauses are valid, but only to prevent the modification of an agreement. That's because subsection 4 of 209 says that even though a NOM clause might prevent the modification of a contract by conduct or oral agreement, a NOM clause does not prevent such conduct or oral agreement from operating as a waiver. This subsection should immediately raise two questions in your mind. First, what is a waiver? And second, how is a waiver different than the modification of a contract? Waiver is not defined by the UCC, but there is a generally well-accepted definition of waiver in the common law. A waiver is when one party who has a right under a contract knowingly and voluntarily, through words or conduct, manifests an intent to relinquish that right. Stated differently, a waiver is when one party voluntarily manifests her intent through words or conduct to relinquish a legal or contractual right. Unlike a contract modification, which requires the mutual assent of both contract parties, a waiver is one-sided, a unilateral act. Either party to a contract may unilaterally elect to waive her rights under that contract. But because waivers are one-sided and not part of a bargained for exchange, waivers are not supported by consideration. Consequently, waivers may be retracted at any time. Subsection 5 of 209 confirms this. Subsection 5 provides that a party who has made a waiver affecting any executory portion of the contract may retract the waiver by reasonable notification received by the other party that strict performance will be required of any term waived. Stated differently, a party who has made a waiver may retract the waiver and insist on strict performance of the contract upon reasonable notice to the other party. So, unlike a modification, where both parties assent to amend their contract, and their assent means that they are now bound to a new contract on modified terms, a waiver is not truly binding on the party who waives a right. A waiver is temporary, in the sense that the waiving party may retract her waiver at any time upon reasonable notice to the other party. That's true unless the other party, that is, the party who is the beneficiary of the waiver, has somehow reasonably relied to her detriment on the waiver. That is, she has materially changed her position in a way that would make it unjust to allow the waiver to be retracted at that point, in which case the party making the waiver is a stop from retracting. This is simply the doctrine of promissory estoppel at work in the context of waivers. Even though the original waiver was not part of a bargain for exchange and therefore is not supported by consideration, detrimental reliance, that is promissory estoppel, serves as a substitute for consideration to make the waiver binding and irrevocable. So, what's the upshot of all this? The key is to understand that a course of performance, modification, waiver, and estoppel are all interrelated but distinct concepts, with different ramifications associated with each. A course of performance that deviates from the express language of a written contract may manifest the contract party's intent to be bound to terms different than what their written contract says, and may thus operate as a modification of the party's contract through conduct in the absence of a NOM clause. But if the party's written contract does include a NOM clause barring modification through conduct, then a course of performance may not modify the contract, but it may still be construed as manifesting one party's willingness to waive one or more of her express rights under the written contract. Unlike a modification, however, a waiver may be unilaterally retracted by the party making the waiver at any time upon reasonable notice to the other party, unless the other party has already materially changed her position in reliance of the waiver, in which case the waiver is irrevocable by estoppel. And with an irrevocable waiver, you wind up in the same place as a contract modification. The right or rights that have been waived are no longer a part of the contract because those rights are no longer enforceable. To summarize, in this video, we finished our examination of contract modifications under the UCC, focusing on the UCC's abolition of the pre-existing duty rule, the implication of the UCC's statute of frauds on modifications, and the effect of no oral modification or NOM clauses, clauses which are enforceable under Article 2 to prevent the inadvertent modification of a written contract, but which do not prevent the inadvertent waiver of a party's rights under the contract through course of performance. In next week's module, we will continue our examination of the terms of a contract for the sale of goods by introducing the concept of warranties.